Hello, everybody. We're just going to give everybody a minute. Looks like everybody's joining right now. All right, we're going to go ahead and get started. I'm sure a few people will continue to join us, but I want to be mindful of everybody's time. My name is Jamie Beck, and I'm the President and Managing Attorney of Free to Thrive. Thank you all so much for joining us today. I'm here with my colleague and our amazing pro bono attorney, Philippa Grumbly, who is an associate attorney at the Cooper Smith Law Firm here in San Diego. Thank you all so much for joining us and to learn about how you can help clear a path for human trafficking survivors through criminal vacatur. I'm going to go through a few housekeeping items real quick. First of all, make sure that you've got your computer, your Zoom set to speaker view. If you go to the top right corner in the view, there's a little box for your viewing settings. You should be able to go between gallery and speaker view. You can go to speaker view. And if you know Zoom well enough to go to your Zoom settings and hide non-video participants, that'll keep you from seeing other people. But if you're in speaker view, you should be fine. If you have any technical difficulties during this webinar, please reach out to our training coordinator, Elaine. We've got her phone number and email there for you. You may want to jot it down real quick if you can, so that you can reach out if you have any issues. But if you've gotten this far, you're doing great. Just so you know, we are on a webinar in a setting where all of the participants are muted. We can't see you. So if you're attending, you're wearing pajamas, that's okay. We can't see you, but we really appreciate you joining us. There is a Q&A at the end of this webinar. We have a really packed agenda to go through today. So you can ask your questions through the Q&A chat box throughout the training, and we'll answer any questions at the end of the presentation. And we will be available to stay longer in case we have a lot of questions. So I don't know about you guys, but it's been a really crazy couple weeks. Well, I do know it for really all of us in many ways, and I'm so grateful to have so many people joining us today. I just want to take a minute to take a deep breath. So if you could close your eyes for just a second. Take a deep breath in, and exhale, release. I'm gonna ask that for those of you, I know it's very easy to multitask during a webinar, and ask if you could just be present with us for this 1 hour, put your phone aside, turn off your alerts, and just stay with us and learn about this one topic. And I will say that through this crisis, thinking about our clients and how we can serve them is what's getting me through this. And I hope that you can learn with us today so that you can join us in helping survivors of human trafficking. So I've already introduced the both of us, but we are your speakers today. And I'm going to take just a minute to show a quick video about Free to Thrive. Some of you may not know more about our organization, so this is just a quick little video to help you learn a little bit more about us. I'm hearing that you guys cannot hear the sound on our video. Hold on one second. Let me see if I can get it to work. And if not, we will skip the video. I apologize. Oh.
Juice Bar here in Bonita, and our mission is to raise the health.
My name is Jamie Beck. Sorry, we got it.
I'm the president and managing attorney of Free to Thrive. I learned that there was not a dedicated legal service provider providing comprehensive and holistic human trafficking legal services. And so I decided to start Free to Thrive, and it's been a whirlwind ever since. I often say that it was like running a marathon while putting on your shoes, because from the second that we said, we're here, we're operating, we're here to help, we started getting calls nonstop, and it really hasn't stopped since then. Free to Thrive operates a mobile legal clinic throughout San Diego County. We have 13 different locations where we provide mobile, trauma-informed, and holistic legal services to our clients. My name is Ashley. I'm the owner of More Life Liquid, cold pressed juice bar here in Bonita, and our mission is to raise the health consciousness of the community. Free to Thrive has empowered me by getting me started on this mission. I had no idea really that I would be helping other women through my business. It's given me hope. It empowered me. It sparked me. Mentoring people, learn more about my purpose in life. It helped me to see that people really care. Like just seeing you and seeing what you're doing and the work that you're doing for all of us in this is like, it's big, and it makes me happy to know like, okay, there are people, because before I didn't believe that there was help.
I'm Philippa Grumbly, and I'm an attorney at the Cooper-Smith Law Firm.
I'm Kelly Larson. I'm a paralegal at the Cooper-Smith Law Firm.
Going into this process, I was excited, but a little bit apprehensive because I practice civil litigation, so I haven't done much work with criminal law. And I was also a little apprehensive because in meeting the client, I wanted to be sensitive to her to make sure that she felt comfortable. And I wanted to be able to portray that to her, that, you know, I was really here to help her. Before we met our client, Free to Thrive came in and trained us, and they sat down with us, and they had an information booklet, and they went through it with us so that we would know what to expect, which was very helpful. And then they attended the first meeting with the client, which kind of helped us get to know the client, and it helped everybody feel comfortable going forward.
Our clients are incredible people who've been through really traumatic experiences and yet are positive and uplifting and determined to change their lives. And we get to be part of that journey with them.
All right, thank you for bearing with us through our technical difficulties. I took my headset off. Hopefully you guys can still hear me okay though. So as we said in the video, we provide mobile, holistic, and trauma-informed legal services to human trafficking survivors. They're mobile in that we go to our clients and meet at safe and confidential locations. They're holistic in that we help our clients with any legal need that they have, whether it's through direct legal assistance with one of our staff attorneys or through a pro bono attorney. And we're trauma-informed in that we work really hard to ensure that our clients aren't re-traumatized through the legal process, and that we take care of ourselves in the process of taking care of our clients. We'll talk a little bit more at the end about some tips to be a trauma-informed attorney. Just to give you a broad overview, oftentimes people, when we say we provide legal services to human trafficking survivors, I think people may not realize the breadth of legal needs that survivors of human trafficking have. So here on the slide, you can see a view of the biggest legal needs our clients have. There's a lot of other needs that come up that are outside of this list, and Free to Thrive helps its clients with all of these things, either directly through pro bono attorneys, or for TNU visas, we do that through our incredible partner organizations. So let's make sure that we all know what we're talking about when we're talking about human trafficking. Many of you may be very well versed in this. I saw some real incredible experts joining us, but some of you may be new to this issue. So I'll make sure we're all on the same page. So human trafficking, essentially human trafficking is exploiting another person for purposes of sex or labor by means of force, fraud, or coercion. When we're talking about sexual exploitation of a minor, there actually does not need to be force, fraud, or coercion. But labor trafficking, whether it's an adult or minor, has those three elements. You know, force is pretty self-explanatory. Fraud is a false promise, and we see that with our clients of somebody promising something to them that doesn't actually come true. You know, we're gonna make a lot of money, we're gonna go out and see the world, I'm gonna take care of you. When those things don't happen, that's a fraud. And coercion is a real nuanced term. It captures a lot of different things, and we do a whole nother training that goes more in depth on the different types of recruitment and coercion that we see. But essentially, it's getting somebody to do something that they wouldn't otherwise do were it not for that coercion. And the three main types of coercion we see are psychological coercion, chemical coercion of the use of drugs or alcohol to get somebody to do something, and economic coercion of exploiting somebody's economic situation. Oftentimes, human trafficking is conflated with human smuggling. Bringing somebody illegally across the border is a completely different crime than human trafficking. If you look at this definition, there's nothing in this definition about crossing a border. So somebody can be trafficked in a single city and never even leave that city, and it's still considered human trafficking if you have these elements. So this is a member report out of Freedom Network USA, and you can see the different types of labor trafficking and how it broke down among those they surveyed. So 52% of people had been labor trafficked and 33% sex trafficked, and then sex trafficking minors 9%, and sex and labor 6%. This is pretty consistent with what we see here in San Diego. And the thing to know is that sex trafficking gets a lot more attention than labor trafficking, but labor trafficking is actually statistically more prevalent than sex trafficking. And this is just a reference to the main human trafficking laws that we're working with at Free to Thrive, because we're looking at the federal law, which is the Trafficking Victims Protection Act, and California Penal Code 236.1. Those statutes are included in your written materials. And the thing to note is that they parallel each other. Most of the state laws are very similar. They're not identical, but they're similar to the federal TVPA, which set our landscape of what the federal crime is for human trafficking, which has been extended and amended over the years. And one thing to really note is that the TVPA was passed in the year 2000. So if you think about the laws, the criminal laws that we have, they've been on the books for the beginning of time. A lot of them, you think of just like assault or battery, for example. When you think about human trafficking, it is a new law. This law is now we're coming up on the 20 years this year, and that's actually a relatively new compared to a lot of the crimes we have, and the laws are still evolving. And what happens is first we have the laws, and then we have victims of that crime. And so victims of human trafficking weren't considered victims of human trafficking necessarily under these laws, and the state laws have been even later to come. So the law is still evolving to look at our client population as victims, and we'll talk a little bit more about that in a second. So human trafficking survivors in our criminal system come up in two ways. They can be victim witnesses of a crime. So somebody has perpetrated a crime against them as someone's trafficked them or exploited them. And often they're victims of a lot of other crimes as well. Domestic violence, sexual assault, a lot of other crimes, unfortunately. And they may be in the criminal system because they're cooperating with law enforcement or cooperating with prosecutors in going after their perpetrators. And sometimes they are involuntarily in that system as a victim or a witness of a crime. And then survivors are also in the criminal system as defendants charged with crimes. So what is vacatur? We're here to talk about vacatur. Some of you may have never even heard this term until today, or until you learned about this training. And vacatur is a form of post-conviction release. So this is something after the fact. Somebody's been charged with a crime, they've been arrested, prosecuted, and then after that case is over, they come back to court and say, I'm a victim of human trafficking and I want to clear my record, and I shouldn't have a criminal record because I'm a victim, not a criminal. And the whole idea behind vacatur is to give a fresh start to human trafficking survivors. It's something that there's nowhere else in the law quite like vacatur, and vacatur only applies to victims of human trafficking. And if you're, I say vacatur, a lot of people don't know how to, or may say it differently. There's really, I don't even know how you're supposed to say it. Some people say vacatur, but just so you know, we're kind of all making this up as we go along, literally, as you're going to see with this training, that this is a very new concept and a new term. So we're going to have a few polls throughout our training today to hopefully learn more about your knowledge and on this issue. So I'm going to hopefully launch the first poll, and the question is, what percentage of sex trafficking survivors have been arrested before? And I see people answering, so the poll is working. I'll give you guys just a second to respond. All right, looks like the numbers are stopping. There we go. And the result, so 46% of you said 90%, 38% said 50%. And I'm gonna close this out. The answer is 90% of respondents to this particular survey had reported having been arrested before. So that is a huge portion of our survivors of human trafficking. And at Free to Thrive, that's consistent with what we see. I would say at any given time, anywhere from 70 to 90% of our clients have been arrested at some point. So when we think about vacatur, we realize that this is something that is a huge form of relief for most, if not all, human trafficking survivors. You can see those poll results here. So if you're sitting there wondering, well, what kind of charges, what are survivors of human trafficking arrested for? You may have some ideas of that. Some of you may know this very, very well, but let's see what you guys think. Launch this poll. All right, so here are some options for you: prostitution, drugs, theft, human trafficking, domestic violence, and all of the above. All right, sharing the results right now. Hopefully you guys can see this. There we go. 92% of you guys said all of the above. You guys are correct. These are all charges that we see on our clients' criminal records. There are also some other charges that were not on that list: grand theft auto, benefits or welfare fraud. And some of you may have been surprised to see domestic violence and human trafficking on there. This is something that unfortunately we do see on our clients' records of them being arrested on domestic violence charges. Often it's their perpetrator who is basically reporting them for being violent against them. And oftentimes our clients will get arrested for that, and then that's on their record. And then human trafficking, there are definitely victims and survivors of human trafficking who are forced by their traffickers to traffic other people. And so that is something that we see on their records as well. Having a criminal record is a huge barrier for anybody to move forward. With our clients, it's a barrier that keeps them from being able to leave their exploiters and to restart their lives. It can stop them from obtaining employment, pursuing their education, renting housing. Most landlords will run background checks. And if something pops up, imagine a landlord seeing trafficker or domestic violence, human trafficking or domestic violence on a record. That's going to be a huge barrier to being able to get a place to live, obtain a loan, and it can really lead to economic instability. And it has huge implications for those that are seeking immigration relief or seeking to adjust their status. This is a quote from one survivor who was seeking post-conviction relief. And she said, "I knew if they fingerprinted me, I'd have to deal with all these memories again. I knew they wouldn't hire me." And that's something that I consistently hear from my clients when they're asking to have help with vacatur. So this map of the country, so I know many of you are joining us, or some of you are joining us from other states. So happy to have you. This training is really going to be focused on California law, but note that a lot of the skills we're talking about, a lot of the tools in putting together a declaration, working with your clients are going to be applicable regardless of what your state's law is, but it's really important to know when you're embarking on this, what your state law is. So this map is from the Survivor Reentry Project, and it's in partnership with Freedom Network USA. If you just Google Survivor Reentry Project, Freedom Network, you're gonna find this. And it's really cool because it's an interactive map where you can click on the state and you can find the state's laws, whether they have a vacatur law. Looks like there's only a few states in the country now where no relief is available, which is pretty incredible. When I first started this work, there was 11 states with vacatur laws. So we've come a really long way in a short time. And a lot of people are doing a lot of amazing advocacy work to get all the rest of the states on board. And if you have a client who, you're in California, but they have a record in other states, this is something that I reference on a regular basis to look and see what the laws are in those other states. And if you want to refer them to an attorney in another state, I highly recommend the Survivor Reentry Project to do that. So why are these laws important? It's about remedying a past injustice. These victims and survivors were arrested when they were being victimized by their traffickers, and they were charged with crimes and treated like a criminal in our criminal justice system. And the idea of this is, we can't undo the wrong that was done to them in any way, but we can remedy that injustice by helping remove this from their record so it doesn't stay with them in the future. It will help hopefully empower them. We've had a lot of clients say how empowered they felt through the process and really when the process was complete. It gives them an opportunity to control the process and to reclaim their story. Oftentimes, this is the first time they've really gone back and reflected on what happened to them, and it gives them an opportunity to look at it with a different light. And it also impacts the criminal justice system. When we go into court on our vacatur cases, all of a sudden the courts, the court clerks, the prosecutors are looking at our clients with a different light. And hopefully not only is it impacting our clients, but it's impacting the other people who may still be in the criminal justice system. Some quick background on California's vacatur law. So for those of you who are not in San Diego, Lawyers Club of San Diego is our feminist bar association here with over 1,300 members. And we have a human trafficking collaborative. If you are here in San Diego, I highly recommend joining this group. It's a really incredible group of lawyers and community members. And we held a training on pro bono representation of human trafficking survivors back in October 2015. And we had Kate Mogilescu come out from New York, who, if you guys don't know her, she's amazing. She's helps run the Survivor Reentry Project that I was just talking about. And she said, I would talk to you about vacatur, but you don't have that in California. So instead, we're going to talk about expungements. And she did. She trained us on expungements. And then we said, well, Kate, what is this vacatur thing you're talking about? Why don't we have that? Well, once we learned what it was, we brought it to the attention of our elected officials. We convened a legislative roundtable in December of 2015. And at that roundtable was State Senator Marty Block, who has since retired. And he got up at that training. He said, I'm going to do it. I'm going to bring a vacatur bill. And we worked with him, and we had Kate also helping us as well, and gave him some examples of other state laws that we could use as a model. And he brought that bill, and amazingly enough, it flew through the legislature and became law in January of 2017. So this is still a new law. We're in our third year, and we're still figuring it out as we go, which we'll talk about more. But that was codified under Penal Code 236.14. So keep in mind, for those of you not in California, these elements are very specific to our law. All the states are different. Some are broader, some are just have different rules. So note that if you're not in California, again, just make sure you're looking at your state's law, but we're going to go through the elements of vacatur in California. So that we've pulled down the statute. It's a very easy to read statute. I will say that if it's going to be in your written materials. If you pull it up online, it's like a page and a half in a PDF. It's very short, which is great because I think it's pretty easy to understand. but broken down into the main elements here. The first thing is having arrests or convictions while a victim of human trafficking. So who's a victim of human trafficking under Penal Code 236.1? We've got our last poll, which I will launch now. All right, I'm gonna end the poll and you'll see the results. I realized as I posted this, I apologize, this is actually a trick question because there was no option for all of the above. So the answer is all of the above. So under the different sections of Penal Code 236.1, forced labor trafficking, adults manipulated into performing commercial sex acts, and minors performing commercial sex acts are all victims of human trafficking. So one of the important parts of this is helping the court understand how your client is a victim of human trafficking, what kind of trafficking they experienced, and how they fit into this statute. The next element is that the offenses have to be nonviolent offenses. So what does that mean? Well, in California, it's actually a very broad term. So, a lot of states' vacatur laws are limited just to prostitution or prostitution-related offenses. Ours is much broader than that, which is amazing. It includes all misdemeanors are nonviolent offenses. Most felonies are actually nonviolent offenses. And it's basically any offense not listed in Penal Code 667.6. We did include a list of what violent felonies are in your written materials, but just know you should always just check the statutes and make sure if you're not sure that that the charges are something that can be vacated, that they are a nonviolent offense. And the important thing to remember too is that even if your client has violent and nonviolent offenses, you can still petition for the nonviolent offenses to be vacated. So they may have one thing that you can't vacate, but then you can petition to vacate the rest. And one thing that may come as a surprise to you is human trafficking under California law is not a violent offense. So it's something that, as I mentioned earlier, it's something we do see on our clients' records. And if it meets all of the other elements, then we believe it can be vacated under this law. The next element is that it is committed as a direct result of being a victim of human trafficking. So this means that there has to be some nexus between the charges and the trafficking. And when I think about this, I think of it has to be like but-for causation. But for the trafficking, this would not have occurred. We'll get into a little bit more details about that in a minute. And the last thing is that there has to be that the survivor has to have made a good faith effort to distance themselves from, as the statute says, the trafficking scheme. And really, what we tell our clients is you have to be out of the life. If you're still, they're certainly not going to be in a place where they're even able to focus on something like this. If our clients are still, in touch with their traffickers or still in that life, we're really focusing on getting them the services and support they need to escape or leave that situation. And once they've stabilized, that's really when they're ready for something like vacatur. But the statute actually doesn't require them to not be a victim of human trafficking anymore, or not still be being trafficked, but they have to make a good faith effort. And then as part of that is it has to, the statute says in the interest of justice. And the reality is like that's the easiest element because it's always going to be in the interest of justice. If we can meet all these other elements, the question, how we convey that to the court is, what is our client doing now and how is this holding them back? Some other points to consider at a high level, the burden of proof is on the petitioner bringing the petition to vacate their record by clear and convincing evidence. So that's a pretty high burden. We have preponderance of the evidence is like 50+1 in our civil cases, and in criminal it's beyond a reasonable doubt. And clear and convincing evidence is in between, but that is a pretty hefty lift. And we'll talk a little bit about how you corroborate these charges or these elements in your client's story, but it's no small task to be able to convince a court by clear and convincing evidence that you meet all these elements. The timing is a due diligence requirement. Basically, it's, you have to bring it within a reasonable amount of time. At this point, the law is so new that it's always going to be a reasonable amount of time because they never could have brought it before. And even when this law has been around longer, your client's always going to have a reason of why they didn't bring it sooner. And you just have to make sure you articulate it to the court in your petition of, why did they bring this now? If they were, if they left their trafficker 5 years ago, why did it take so long? And there's always going to be an explanation. You just have to make sure that you touch on that. And there actually is there are 2 bills right now in the California legislature that would amend this law, and one of the things has to do with that timing requirement to add some more clarification. The statute does provide for consolidation from different jurisdictions. So it says you can file a single petition in a single jurisdiction. As we've been doing this for 3 years, we realized along the way and learned from just learning this on the ground is that while the statute says that, the courts are really not equipped at this time to consolidate petitions. And so what was happening is that petitions were getting granted, but then the records weren't actually getting cleared. And so as a result of that, we now are filing separate petitions in different jurisdictions just to make sure that the records actually get cleared, which does add a lot of hurdles to this process. And there's a lot of lawyers working on the ground with the courts to try to get to a point where we can have consolidated petitions, but we're just not there yet. So my advice at this time would be to file separately. And this, for some clients, it may be 2 or 3 jurisdictions. For others, it may be a lot more. So it can be a really challenging process if we're talking about a lot of petitions in a lot of places. But the ultimate goal is to get the record cleared. And if we're not confident that you're going to be able to clear the record, then it's better to just do it one at a time. And even if it takes longer, it's still worth it to go that extra step at this time. Hopefully that won't be the case forever. The statute also provides that the prosecution must be served with the petition and that they have 45 days to respond. If there's no opposition, the court shall deem the petition unopposed, but it doesn't say must. So the court still potentially could deny a petition that is unopposed, but so far we haven't had that happen, and they may grant the petition. In our experience, if it's unopposed, we have not had a court not grant it. The statute also provides for a hearing, and the reality is that we actually don't know a whole lot about how these hearings work. Like I said, if it's unopposed, the courts have been granting them, and the hearings for the unopposed petitions have gone incredibly smoothly. We go into court, we share with the judge that it's unopposed, and the judge grants it as a matter of course. And in best case scenario, commends our client, which you'll hear about a little bit more at the end of one client's experience. But if it's opposed, honestly, fortunately, we have not had any opposed, so we don't know what that looks like yet. That being said, my prediction of what an opposed hearing would look like would be similar to a domestic violence restraining order evidentiary hearing, where it's going to be basically like a mini bench trial where we're going to bring evidence, put our client on the stand and have them testify about their experience. It's something that I prepare my clients for in the event that it happens, but I also tell them that we think it's unlikely that they would actually have to testify at a hearing. And the statute does provide for video and telephonic appearances. However, the courts have not really been set up to do that. So it's something that you have to address on a case-by-case basis. And one of the bills I mentioned, that's one of the things that they're looking to do is to clarify under what circumstances somebody could appear by video or telephone. So we'll see. We'll see when the legislature goes back to session, and if those bills pass, the law will change slightly. So keep an eye on that. The results of vacatur are profound. It requires the sealing and destruction of all records. This means DOJ records, court records, fees and fines, except restitution. This is the one area that still the law requires you to repay restitution if it was ordered. It also gets rid of all these other things: fingerprints, booking records, police and arrest records, probation records, parole and DNA profile being fully destroyed. So this is a very big result for clients. The reality is that actually getting these things done is a whole nother story, and we'll have an advanced vacatur training where we'll talk a little bit more about that today. But it's, you know, just like anything else, having a judgment is a piece of paper. Having an order for vacatur is also a piece of paper until others do the work of getting these things cleared off. So yes, the court says they need to do all these things. You know, our DNA profile is being destroyed. I have no idea, but if I had to put money on, I would say probably not. So you guys are going to get the slides afterwards. I'm not going to go into detail on these two slides, but I wanted to include it so that you have it of the difference between expungement and vacatur in California. The biggest thing to know is that an expungement still shows up on your record as dismissed. So if somebody runs your background, they're going to see the charges even though it says dismissed next to it. Vacatur is completely taken off your record, and it's deemed not to have occurred. And a really important thing is for employers, when especially if your client wants to go into a licensed profession, they can actually answer no to any question because it says it's deemed not to have incurred. And so they can check, no, I've never been arrested for a crime, and not have to disclose that. And in the licensing process, it also doesn't have to be disclosed, whereas something expunged would still have to be disclosed. So something to keep in mind is that survivors who have been arrested, they might not remember all their arrests. The details may be fuzzy. We'll talk a little bit more about that. They might have open warrants, and that's something that we work closely with the public defenders in whatever jurisdiction they were arrested to have those warrants removed. But they may come in and they just want to clean up the record, and they don't know that they had a failure to appear, and they actually have an open warrant. And those are things that you'll definitely want to resolve as quickly as possible. And if you're a pro bono attorney of ours, we would work with you on that. And they also might not know what appears on their record at all. They may say, I know I was arrested, but I don't know what it was for. I think it was for this. So these are things that, you know, these are hurdles that we work through with our clients. So now I'm going to turn it over to Philippa, who's going to dive into the nuts and bolts of what you need for this relief.
All right. Thank you, Jamie. So where to begin, the nuts and bolts of preparing the vacatur petition. What you're going to need is to prepare points and authorities, setting forth the law and the elements of why your client is entitled to the relief. And then the most important part is your client's declaration, which sets forth their story, you know, where they've been, what they've been through, and how they separated themselves from trafficking. And along with the declaration, what you want is also to provide corroborating exhibits to support the story. And I'll touch on that again in a bit, but that can be difficult because you know, it's difficult to provide documents to show that your client was a victim of trafficking. But so you have to be a bit creative with it. But any sort of corroborating exhibits to support your client's story help them in in achieving the relief they need for vacatur. And we'll go to the next. Yeah, thanks. So to prepare the petition, the first step that you want to do is you want to meet with your client to get their story. And when you meet with them, what's really important, especially because they have been through this trauma, is to establish a rapport with them. So the best way to do this is usually to start by discussing easy topics as opposed to diving into their past. And easy topics would be what they're doing now, what they've accomplished since leaving the life, you know, what their family situation is like and how they're doing. And once you kind of establish that rapport, you can go back through and start at the beginning and get the full story. Another thing to be aware of is that you should be sensitive to how your client would like the trafficker identified in the petition. A lot of clients don't really want the trafficker identified by name. They still, you know, they feel concerned about this and prefer to use kind of a pseudonym, which is fine and it's not a problem. But just to keep in mind that often the prosecuting agency will want the name of the trafficker, which can be provided separately outside of the papers, because they'll perform a background check just to corroborate your client's story. So if the trafficker was in jail and your client says the trafficker was in jail, you know, a certain number of years, the prosecutorial agency likes to check that to corroborate the story. And then one of the most important things I think to keep in mind when meeting with the client is that it's not just about getting vacatur relief. It's also very therapeutic for the client. And they're telling their story and they're having it validated that, yes, these things happened while they were a victim of trafficking. And I think that's important to keep in mind through this process. So as part of preparing the petition, you need to find out your client's criminal record. And you can do this through a DOJ report, which in my experience, Free to Thrive has done that. They provide the DOJ report, and then that's what I use to prepare the petition.
And I'll just jump in here and share. I know we have a lot of nonprofit attorneys on this call or on this webinar, and there is actually a law was passed, I think, a year or two ago. I can't remember how long it's been now, but that allows people doing post-conviction relief to get copies of their client's record. So there is a process by which you can do that. And if you reach out to us, we will walk you through that. But it's essentially just filling out a form and making, having a point person at the DOJ that you can get that from. And if your client says that they have arrests outside of California, then I highly recommend also doing an FBI background check, which will bring up those things as well. And you can use that to then help them find an attorney in another place. You know, ideally through the Survivor Reentry Project, but your firm may have people that are licensed in other states, or you may have contacts in other states, but you're going to need that FBI background check in order to know what's on their record.
So the next part is preparing the declaration to support the petition. And you do that by meeting with your client and getting their story and looking at the records. And as Jamie mentioned, a lot of times clients can be a little bit fuzzy as to the details or the timeline that occurred. So what's helpful to use is anchor dates. Dates when you know something occurred, and then that helps them fill in the gap in between. So for example, the date their child was born. A lot of times clients can use that to kind of remember what happened before and what happened after. Dates of particular arrests or convictions might also help to kind of refresh your client's memory as to what happened before and after. So you can also use police reports, which can be difficult to get, but if you can get them, you can use those to help fill in the details, as well as copies of court records. Can also be used to kind of fill in the timeline, and then you use the narrative to fill in the gaps in between and kind of give more context to it and explain what happened. So the declaration that are important to include your client's background, what particular vulnerability they had that perhaps made them more susceptible to a trafficker. It can be economic, it can be their family situation. There's lots of different vulnerabilities that can make a person appealing to a trafficker as a victim. And then of course you want to include in the declaration the client's actual trafficking experience and tie it to the convictions. So these arrests and convictions occurred while they were trafficking because of the trafficking. And then you also want to include what's happened since they've left the life. Post-traffic, how have they separated themselves from their past to show that they would benefit from vacatur. Other points to consider for the declaration are giving your client control over it. These are people who have been through a lot of trauma, and it's important to have a relationship of trust with them, and also for them to review the declaration and make sure it really tells their story, that it has in it what they want to say. And if there's something they don't feel comfortable with, that's it. And then as far as how much history to include in the declaration, that's really difficult. It's on a case-by-case basis. You have to talk with your client and see what he or she feels comfortable with, and then make that decision of what's appropriate to include. And then in addition to the declaration, as I mentioned, you want to have documents to corroborate the narrative. And this can be difficult because what documents can you use to show that your client was a victim of trafficking? So you have to be a bit creative in how you think of it. So here are a number of examples, but to kind of provide some context of how it might be used is your victim was in school and then they became involved with the trafficker and they withdrew from grades, declined. You could use school records to show a school transcript to kind of, you could also use letters from family members. You know, they observed the client, saw what happened, you know, and what happened to the client and how the client has now separated themselves from that experience. Additional issues to consider. Old convictions where corroborating evidence is difficult to gather. That can be difficult because, you know, if you have a conviction that occurred 10, 15 years ago, how do you gather evidence to support that it occurred in the course of trafficking? And that's, again, you have to be a bit creative, you know, whether you can use family members' declarations or school transcripts, employment records. You have to kind of think about this and then supplement it with the client's own narrative telling their story. And then as far as non-citizen clients, those cases can be more complex because you don't want to affect, you don't want the vacatur petition to affect their immigration status. So in situations involving non-citizens, you'll want to work with an immigration attorney, which Free to Thrive can assist with and provide some references for. And then convictions after the defendant has physically escaped the trafficker. This is not that uncommon. And I think a lot of times you have to look at the overall picture, whether conviction occurred because of the trafficking. In other words, but for the trafficking would the conviction have occurred. So a lot of them, though they have just escaped their trafficker, there's still repercussions from that. They're kind of under control. They don't have economic stability. So maybe prostitution is their only choice. So there's a lot of ways it can still tie into trafficking. Obviously, if it's something totally separate that occurred years later, then that's not subject to vacatur. And then throughout this process, it's really important, as it is with any client, but particularly here, to keep your client updated and to build trust with them. So they know what's happening and they feel comfortable with the process as it goes along. And then a lot of client about this, you have to be able to, you know, work with your client and answer their questions as best you can. And one of the questions that comes a lot is how long does it take? And that's a difficult one to answer because often it depends on a number of factors. It depends on the client and how comfortable they feel telling their story. So it can take several meetings to feel comfortable to tell the whole story. Sometimes it depends on how many convictions and arrests they have and in how many jurisdictions. If there's multiple jurisdictions, it can be slightly more complex. Usually the process takes at least 6 months. Some take more, some take less, depending. And then, is my information public? Will anyone know this motion? Well, the filed under seal, and we use the client's name when filing. We use initials, so that's a level of anonymity in the process. And Free to Thrive works hard to try to get it as private as possible. And I have to appear in court to testify. That really depends. From what I've seen, no, not usually, but I mean, Jamie might have other examples to provide, but if they do have to appear in court, you can tell them that you're going to do everything possible to make it as private as possible. You can ask for the courtroom to be cleared. You can do a number of things to try and help the client feel comfortable. And then what happens if we win? Well, your record is vacated. Your background checks will turn up clear, and that'll help you throughout your life. What happens? Lose, you're not really in a worse position than you were before. And then pros and cons of whether you want to bring a petition again and try again. So that just really depends on the specific case and the situation of why vacatur was not granted. Then I'll turn over to Jamie to talk about various restrictions.
All right, thanks, Philippa. So when we're talking about filing, one thing that we've learned is it really varies by jurisdiction in terms of what the process is. Here in San Diego, when the law first went into effect, we immediately started meeting with the DA's office, the city attorney's office, the public defenders, and the courts, all to create a protocol here in San Diego to streamline petitions. And I often say San Diego is like Kumbaya Island because we're all getting along and working really collaboratively. We've got a single deputy district attorney and a single deputy city attorney who are our point people. We actually have a process where we send them our petitions pre-filing, and we have this like interactive dialogue with them of we send it over and you know, they say, hey, you know, this looks good, but I have questions about this. Or like Philippa said, I need to know the trafficker's name because I want to look them up and see if they're the person that, you know, if their record matches what your client is saying about them. And we go through this, you know, back and forth a little bit. And in the event that they agree that they're not going to oppose the petition, we actually file a joint stipulated petition, and we file just that with the court. We have a single, it's our criminal presiding judge who is the judge who reviews these petitions, and that really having a single deputy DA and a single city attorney and a single judge and courtroom where this goes is, I can't even begin to tell you how helpful that is to the process. And to the extent that you can work towards that in your jurisdiction, that is like, you know, best practice. It's going to really help, you know, make sure when you file, you know, like even if the DA comes back and says, no, you know, we were not agreeing to this, and at least going into it, we know what are their concerns about it, why won't they agree, and we know going into it. And then we have a single courtroom where the judge has seen these before, knows what they are. This is a new thing, and there's not a lot of familiarity with it, which, you know, segueing into other jurisdictions, our experience has been that the first time we get into a jurisdiction that we haven't previously been in, there is really a lack of knowledge around this when it's everybody. It's the deputy DAs and city attorneys, it's the courtroom, the filing court clerks and the court clerks, the courtroom clerks and the judges. They've never seen this before. They've never heard of vacatur for the most part. And so there's a whole process of educating them. And in one case, I was filing a couple of petitions in Los Angeles, and it took me, I kid you not, 4 hours to file it with the court because they didn't know what it was and they didn't know how to file it. And so this has been, it's been a journey. But once we've done it, then they know what it is. And the next time we're there, they'll be a little bit more familiar with it. It's really important to keep that in mind, and keep in mind, you know, if you're doing a lot of these petitions, I mean, if you're a pro bono attorney, you're getting your cases from somebody else most likely, and they're screening these for you. And as a nonprofit, we really started with filing our easiest ones first. We started with very straightforward, you know, single jurisdiction and 2 prostitution charges. And it wasn't until we had the court comfortable and the prosecutors comfortable with what we were doing that we've started to file our more complicated ones. So keep that in mind in terms of just an overall strategy. And, you know, if you're in a jurisdiction outside of San Diego, you know, one, we want to know how that's going for you. And we will talk about that at the end, that we're available to help you through this process as you navigate that jurisdiction. These are just the elements. When we file a stipulated petition, where it literally is just the elements. So the incredible thing is in San Diego, our client's story is not being filed with the court at all. It's, you know, we all agree that this client meets these elements. And the key to, just going back a second real quick with the San Diego protocol, is that it's corroboration, collaboration, but corroboration. So we're working really collaboratively, but they're also reviewing these very, very carefully. And so, you know, if they have any concerns or questions, we really need to be able to back up our client's story with some sort of corroboration. And, but once we get to that point, we file this joint stipulated petition, and then we get the court to sign it, and they really, you know, trust that the DAs and city attorneys have done their due diligence on these, and that if we agree, they're going to grant it, which has been amazing. So I want to take a few minutes, I'm just going to check the time real quick, to talk about, how we work with this client population. So our clients have very severe trauma. It's akin to that of a war veteran in terms of they have severe PTSD, and how that manifests is challenging for our clients to go through this process, because we're asking them to revisit memories that they, have probably filed away in their brains to keep themselves from having to think about those traumatic things that happened to them. And we're asking them to go dig back up those old memories that they don't want to think about, so that, they can help us through this process. And that's really hard. So some tips are, to practice active listening, to validate their experience. And, sometimes, just sitting with them as they're processing what happened to them is all you can do, is to say, I'm really sorry that happened to you. You can't, it's some really tough stuff that you're going to hear about. And, sometimes, you just have to be with them and be present for them as they relive this, and be willing to take breaks often, and just take it at their own pace. Also providing them with decision-making power, as Philippa said earlier, is really important, so that they control the process. Another thing that's really important with survivors of trauma is being very clear with them about the process, like every single meeting. And one thing about trauma is their memory may not be good. So you may explain to them in the first meeting, here's how the process works. We're going to do this and then this. And then the next meeting, they'll say, what's the process? What's the timeline? And you may have talked about that in depth at the last meeting, and you're going to talk about it again. And every single meeting we start with, just checking in and seeing how they're doing. As Philippa said, if you start the story with, what are you doing now? It also gives you an opportunity to learn about them and their lives. So if you learn that they have kids, how are your kids, or how's your job? I know you were applying to school, how's that going? And then transitioning into, okay, here's what we're going to do today. We're going to talk about, your childhood. And if we have time, we're also going to get into the charges and look at your criminal record together. And then you finish the meeting with, okay, thank you so much for sharing that with us. And sometimes it'll be very clear when that meeting needs to end, because your client just kind of hits a wall in terms of their ability to talk about their story. And oftentimes, this is a good stopping point. Why don't we stop right here? And next time, here's what we're going to do. And then you give them a roadmap for next time. And then communicating with them along the way. Oftentimes once they finish their declaration, it's our job to then do the petition and either do the pre-filing process or file it with the court. And each of those steps takes time. So, once they're done with the declaration, you say, we've got your story. Thank you so much for sharing that with us. Here's what we're going to do next. And then keeping them updated of, okay, we've finished your petition. We're going to send it over to the DA's office. And sometimes it can take them up to a month to get back to us. So, we'll please circle back with us, or we'll circle back with you when we hear anything. And just stay in touch with them, because the whole time, you're going to go on and do other things. They're going to be thinking, what's going on in my case? And then making sure that they have supportive services. If you're working with a Free to Thrive client, that's something that we work really closely with our clients, and making sure that they have the services they need to both, take care of themselves, and particularly their mental health through this process. And if you're, not working with a Free to Thrive client, just do everything you can to bring in those services at the beginning or as soon as possible. Other things to note, and we're going to have a whole nother training that's going to go really a lot further in depth in this. We're just scratching the surface here. But trauma impacts your memory. And what that means is that their stories may sound sketchy or fragmented, because they're not going to remember all these things. Like I said, they filed those memories away, and their brain is protecting them from having them fully present. And so they may really struggle with a chronology when you're trying to say, well, when did this happen? Or they may give you inconsistent facts, and you realize that. And the important thing is to remember that this isn't them being evasive or lying, but it's them being victims of trauma and understanding that and meeting them where they're at and saying, that's okay if you don't remember, we can come back to this next time. Or like Philippa said, using anchor dates to at least narrow down the timeline. Okay, was it before or after your son was born? Oh, well, my son was walking by then. And so, okay, well, they were less than a certain age, because how old were they when they started walking? So you're going to be able to use things to narrow that down. But we often use language that helps caveat a little bit of it was around this time. We try not to use very specific language if our client doesn't have a specific recollection of when something happens. And just remember that, never lose trust in your client because of this, and be honest with them and say, you know, last time you said this and this time you're saying that, and I just want to make sure that we get this right. And if you don't remember, that's okay, but let's see if we can narrow this down a little bit better. Other things to keep to consider are things like your atmosphere of where you're meeting. So if you know, right now we're in a different world. We are doing all of this remotely with our clients. We are absolutely still working on vacature right now. So it's going to look and feel differently. We're doing this telephonically or via video conference with our clients, which is obviously less than ideal in being trauma informed. But when we are back to meeting with people in person, you know, be mindful of where you're meeting with them. If you are at a law firm, if you meet with them in a big conference room, that's going to be really intimidating to them. So either meeting them at a location that they feel safe and comfortable, or, you know, using a small conference room. And things like, you know, we have some conference rooms that I call like fishbowl rooms, where it's glass windows and they're really beautiful conference rooms, but then you feel like you're in a fishbowl, and your client could, you know, have people walking by looking at them, and that's going to make them feel self-conscious as they're pouring their hearts out to you of this traumatic experiences that happened to them. So trying to meet in a room and in a space that is warm and inviting and comfortable. You can't always control your space, but to the extent that you can, just be mindful of that. And some people going into this who haven't worked with this population before, you know, may not be sure, well, I don't know how to work with them, and I don't know what that would be like. And the reality is like, survivors of human trafficking are humans. They're people just like everybody else. And the most important thing is just to be authentic. They have very strong bullshit meters. They know if they know they've been through a lot. They've been through a lot more than most people have. And so they're going to know if you're being genuine or not. And the best thing, and even to be like, you know what, like I may say the wrong thing. And I just want to say at the outset that if I do, let me know. And I'm really sorry. I may use the wrong words, but just know that I'm really doing my best. And let me know if I say something that offends you. And I promise I won't say it again. And I'll be mindful of that. And it also makes you a little bit more vulnerable. And, you know, it's also humbling a little bit to realize, for your client to realize, like, they may see you as in your ivory tower as this lawyer who knows everything. And the reality is we really don't. And we're relying a lot on them. And that helps kind of shift the power dynamic a little bit. And, you know, keeping in mind the power dynamic is, especially if you're, you know, hopefully you're not charging for this service. And if you're assuming you're not, then they're getting a service for free, and they may be thinking, well, what's in it for you? Why are you doing this? What's going to happen? Oftentimes when I tell clients we don't charge for our services, they just can't believe that a lawyer would help them for free. But they may be thinking like, you know, there's going to be something in it for them, and you really have to help them understand what you're doing and why, and find ways to make sure that they understand, like, just because you're not paying me doesn't mean that you can't fire me. When we go through our engagement agreement with clients, we always make sure to mention that, you know, you are hiring me and signing this agreement. And if you don't like working with me or working with Free to Thrive, you can fire us too, and giving them that power and control, which they haven't had in the past. And I already mentioned the therapeutic support is going to be really important. So it's also, you know, those of you working with any sort of indigent or marginalized populations will know this very well, is that there's going to be a lot of other needs that come up, particularly in this moment in time. I expect that to only increase as things get harder for everybody. And so it's important to make sure that you have those resources available. And if you don't, make sure that you're working with someone who does. So if you are a pro bono lawyer, make sure you're working with a nonprofit that has services available. That's something that, if you're one of our pro bono lawyers and you say, hey, you know, I just found out that my client's homeless. You know, she was living with a family member when we started, and she's been kicked out since. We will immediately intervene and work with that client to help them get housing and support so that they're not in that situation. Those things are going to happen, and unfortunately happen all the time with our clients. And so just making sure that you have those resources available, that you know who in your community provides those resources, because it will come up. So to give you an overview of the pro bono programs that we have obviously our vacature program, which is what we're all here talking about today, which is open to an attorney of any kind. You can be a retired attorney as long as your license is still active with the California State Bar. You do have to be licensed in California to do criminal vacature with Free to Thrive, because we only take cases in California. But even if you're a transactional attorney, we have a lot of transactional attorneys who have never done this type of work before, and with training, I firmly believe that anybody can do it. All of your cases will be pre-screened, so we'll already have gone through those elements of vacatur with the client to see if they meet those criteria, and if so, we'll have reviewed their Department of Justice, their background check with them to see if their charges fit within the statute, and only then refer it. And then we'll work with you along the way. We're not just going to hand off a case to you and say, good luck. We will be there to support you through the process. We'll help you review drafts of the declarations. We'll help if issues come up along the way. And we really hope that, you know, anybody can do this work. We also have a family justice program that helps clients with divorce, child custody, and restraining orders. We do that work directly with our amazing family law attorney, who you're going to see in a second when we get to Q&A, Nick. But we also have pro bono attorneys that support our clients. This need is far greater than we could address with a single staff attorney. So if you are a family law attorney and that's your practice area, you know, please take on a family law case and work with our clients in that way. And then if you're like, you know, I'm not a family law attorney and vacatur sounds really interesting, but that sounds way outside my wheelhouse, that's okay. We actually have a specialized pro bono legal services program where we help our clients with all those other legal needs that we mentioned at the beginning of the training. And you can take a case in your specialized area of practice. So if you want to help a human trafficking survivor, you can go to our website and click under volunteer. Or we're going to send an email following this that'll have a link directly to sign up as a pro bono attorney. And if you're not an attorney, you can also go to our website and sign up as a non-attorney volunteer. We do have volunteer opportunities for non-attorneys, and for law students, we have internships as well. So I mentioned that we do provide technical assistance. So if you are a pro bono attorney, Erin Hiltz is going to be your point person, and if you're a nonprofit attorney and you're taking these cases, you're you know, we're partnered with nonprofits throughout California who are also doing vacatur work, and we can definitely be a resource to you as well as questions come up. And this is something that we are all in touch with each other, the few of us that are in this space, on a regular basis of, oh, I'm filing in this county, you know, what has your experience been there? And oftentimes the response is, you know, we've never been to that county before, I have no idea, but let me know once you do file so I know what that's like, so when we get into that county. But if you have questions along the way, either myself or Erin Hiltz, who is our coordinator of that program and our staff attorney, can help out. And if you are outside of California and are interested in starting legal services for human trafficking survivors and you haven't done this before, or you're new to it, we also do consulting with other nonprofits and other attorneys to help them get these programs started elsewhere. There are a lot of states without legal services for human trafficking survivors, and that's something that we really want to change. So if you are embarking on that journey, please reach out to me, and I would really love to work with you and help support you as you move forward. I've been through this journey starting Free to Thrive myself, and it's always nice to have other people who've been there. A couple of upcoming training opportunities. We will also send this out by email, so no need to jot them all down now. You'll be getting this by email, but we're going to do a training for the entire community, not just lawyers, on the impact of COVID on human trafficking victims and survivors. We're going to do a 2-part trauma-informed lawyering series in May, where we're really going to dive a lot deeper into a few of the things that we touched on today. And lastly, in June, we're going to have an advanced vacatur training, and that's for people already working on vacatur cases to help them. And it's really going to be more of a town hall style than a substantive training for us all to talk to each other about what we're seeing and experiencing. But note that this is something that the courts are closed, and there's not a whole, you know, there's a lot of practice areas that just nothing is going on right now in your area. This is something that we can absolutely still be working on. These cases take a while, and so it's a really good time to work on this, because all those, you know, court cases that are keeping us busy, or transactions that may have just come to a halt, this is a time that you can still have an impact and do some really amazing work. So I'm gonna show you guys one last video before we wrap it up and open it up to questions.
When I first connected with Free to Thrive, I was not identifying as a human traffic victim. I was like, no, I chose to live this life. But a few friends had told me about the program, and I just was not ready to do the process.
The first time we met, Nisha, was a really exciting moment, because I was very excited to begin this process and to help out. But then when I met Wilnisha, I was blown away by her.
You know, now that I'm more open to identifying as a human trafficking victim, like I want to work with youth, or I want to work with women and help empower them and let them know like there's life, after the game. Hello everyone, my name is Wilnisha, also known as Truth, and I'm an artivist. So pretty much I use my vocal abilities and my voice to speak for those that don't have a voice. In my day job, I am a case manager for San Diego Youth Services. I work for STARS, and we work with youth that have been human trafficked. I help them with whatever needs they need help with. I just want to empower them to help them change their lives and let them know that I too am a victim of human trafficking. And if I can change my life, they can change their life too.
I mean, here is this person who has gone through considerable trauma and had a lot of difficulty in her life, but she's so upbeat and happy and such a positive person that it inspired me, and it impacted how I saw everything else in my life. And it just made it mean so much.
My experience going to court in Orange County for my vacatur hearing was very restorative. Jamie was so like open. I was like, Jamie, can you take me? She was like, yeah, I'll take you. So she met me, drove me all the way there, so I was able to calm my nerves. I was able to relax. And she really talked me through the process of like what she expected to happen. So when we went in the courtroom, we had just got there from San Diego, and the judge was like, I want to see Wilnisha. I was like, oh my God, like, can I breathe? Like, I just got here, but I was still sweating from walking up the stairs. But anyways, I went to the podium, and my pro bono lawyer had talked to the judge, and the judge was like, I read over your case. Keep in mind, like, it was a courtroom full of people, like a traffic court, and I thought that this judge was gonna like out me and tell my story, but he didn't. He kept it very professional. I read your story, and I'm really proud of you. The way you changed your life, and who did that work, and who made all this happen. You did, and it's just amazing to see you stand in my courtroom today. I would love to come off my bench and shake your hand. And I was like, wait, what? Did I hear that correctly? And he was like, is that okay? Like, he asked for consent too. I was like, sure, come on down. So he came down and shook my hand, and like a firm handshake, and the whole courtroom just started clapping. And I was still in shock. Like, I can't believe this is happening right now. And so me and Jamie walked out of the courtroom, and Jamie was like, that was amazing, Wilnisha. This has never happened before. And I was like, it is amazing. And it was like total healing. I felt like I was definitely restored from my experience getting arrested in Orange County to now having my vacatur and it being granted in Orange County.
To me, empowerment is being a leader in your community, being able to influence others in a positive manner. And I think that Wilnisha is a perfect example of that. And I'm glad that we were able to help her continue to make that happen.
Hold on. Working on getting this out, getting to the next slide. Give me just 1 second, guys. There we go. Okay, sorry about that. So as you can see, the impact on this remedy on our client population is absolutely incredible. I am thrilled to share that this past year, Wilnisha received our Thriver Award, which is an award that goes out to a survivor who inspires us. And Philippa and Kelly, both at the Cooper Smith Law Firm, received our Advocate for Justice Award. And really, they embarked on this with an open heart and willingness to learn along with us, and did an incredible job. And this is something that they've actually already taken on another pro bono case, which is I'm deeply grateful for. But it's really incredible how impactful this relief is, as you heard from Wilnisha. So with that, I want to turn it over to questions. And I know we've got some questions in the Q&A box. I know I think we're right at time right now. So if you have to jump off, we will not be offended, but we have our contact info here. And if you're able to stay on for Q&A, our staff attorney, Nick Moore, is going to moderate the Q&A for us. Hello.
Hello. Can everyone hear me?
Yes.
Okay, great. Thank you, everyone, for the wonderful questions. I've answered several of them, and we're going to make a transcript of the answers and questions available after the presentation. One of the things that Wilnisha said that stuck out to me that I learned when I started doing this work was a lot of victims are not eager to be identified as victims of human trafficking. The studies that we've seen suggest that sometimes it takes more than a dozen contacts with law enforcement before they realize the extent to which they're being exploited. Very oftentimes, people enter this type of life with some feeling of voluntariness, and so there's a degree of guilt or shame for them that relates to their exploitation. And that's kind of my lead into this first question from Denise, which is how do you handle CSEC with minor on minor? CSEC, CSEC stands for commercially sexually exploited child. These are case-by-case basis. You know, the way law enforcement handles them, the way courts handle them is really unique to the specific facts of that case. There is just no pattern for how, you know, these types of cases ought to be handled because they are on a fact-by-fact basis and a case-by-case basis.
Yeah, and one
definitely.
thing,
go ahead.
Sorry, one thing to note is that when we're talking about charges as a minor, one of the threshold questions is this something that should be sealed or vacated or both? You know, sealing is going to keep the record from the public view, but it doesn't go away in the same way that vacature would. But in a case, you know, and our response to that is, you know, both is best, and you kind of have to figure out the timing of which you would do first. We have a client who's got a record from when she was a minor and then as an adult, and the minor record is likely not eligible for vacature, and so we'll probably end up sealing that record and then vacating the rest. But it's something that also keep in mind that you may be able to seal it even if it's not eligible for vacature.
Next question from Ali Keegan is, are there prerequisites for vacature eligibility similar to expungement, just having successfully completed probation, parole, not serving a sentence for another offense, etc.? And no. Surprisingly not written into that law, into Penal Code 236.14 are those types of prerequisites. There is a caveat, for example, that if there is an expungement, or not an expungement, if there is vacature granted, but there's an outstanding restitution order, right? The vacature doesn't affect the restitution order. But we really are just talking about records, and there are no prerequisites other than the nature of the crime.
Which means they can still be on probation when you file for vacature. Certainly the further out you get from the charges, the more you'll have to say that they've moved past that experience, but there's nothing that says you have to have completed probation.
Aradhana Tiwari, I hope I'm pronouncing that right. I'm very sorry if I'm not. Asks a great question though. Do you have to disclose prior offenses or arrests if they're vacated? For example, on immigration petitions, a common question is, have you ever been arrested, charged, convicted anywhere? If a record is vacated and the individual has no other record, is the answer no? This is something that we do not know the answer to, and it sort of varies depending on the application. So for example, vacature is a California law. It only affects California Department of Justice records. It does not affect federal Department of Justice records or FBI records. There is no process to expunge or remove crimes from those records. So for example, on an immigration petition, they should still, I think, answer the question that they have been, because that's what the record will show when federal immigration authorities run that background check. Same if they're applying for a federal firearms license, and same if they're applying for anything with a security clearance, though I don't know that would happen. We are of the belief, and there's no case law on this, unfortunately, but we are of the belief that a vacature petition is a petition for factual innocence. And so that they should be able to answer no to those questions. Petitions for factual innocence can be found under California Penal Code 851. It's a very high standard to meet in order to vacate a crime. Essentially, that's what has to be shown. We are of that position, but we don't want to be giving people the type of advice that perhaps you should say no on an immigration form, simply because we understand the types of records that we know immigration authorities are going to be drawing from. And if they say no on an immigration application and there's very clearly an FBI record, that'll present problems. And that's probably something that's best sort of discussed with the immigration attorney and the client in that particular answer. However, for job applications in California, we say, I am comfortable telling people that they should answer no if we have fully vacated their records. Sometimes when we do vacature petitions, we can only remove some of the charges and not other charges. That's, again, it's a case-by-case type answer.
And one thing to add to that, and great answer, Nick, thank you, is that it also depends on where you are in the process. So as I mentioned, there's a time lag between when you get the court order and when a record will fully come back clean from the DOJ. And so, we advise our clients during that time period that, they can advise if a potential employer is going to run their background, they may want to disclose it and say, I have a court order vacating it. Or they can wait and see. Sometimes it's been strange because sometimes the DOJ doesn't come back clean, but the employer does not get anything back on their record. Don't know how that works, but it's just something to note that they may need to disclose it. And what we always offer is that we can provide a letter to the potential employer if it does pop up and help them understand the process. The ultimate goal of vacature is they never have to disclose this again, but there may be a period of time in which they do. So and just know that your clients should be in touch with you on an ongoing basis if they're applying for jobs, and they should ask you for different situations. Should I disclose it? Do I need to? And you really have to do it on a case-by-case basis.
Rachel asks a question: to the extent that the DA does not agree to a stipulated petition, can you discuss what the major areas of concern tend to be? To the extent that the district attorney would not agree to a petition is generally if they are not persuaded that there's a nexus between the crime and the victim's trafficking experience. That's probably the single major area of concern. We haven't had this yet where the district attorney has outright felt like there's no nexus, but they have expressed sometimes a concern given the materials that are submitted, and that's usually on a case-by-case basis as well.
And the other thing that has come up is just lack of corroboration of, they say, yeah, the story makes sense. I believe that your client was a victim of trafficking, but we need more supporting documentation to back that up, which sometimes can be really challenging.
And Rachel also asked to discuss the nexus element further. That seems like the potentially trickiest area, and yeah, it is. It is tricky because we live in a society that places great demands on people to take responsibility for their actions. And so if the charge itself is not a PC 647B, which is loitering or prostitution type charge, then it seems like sometimes the baseline assumption is, well, how does this relate to trafficking? So for example, if it's petty theft, if it's check forgery, these things may not on face appear directly related to their trafficking experience. And so we have to really strive to tell the story about how a victim of trafficking is always in survival mode. The nexus is shown, I think, through empathy more than anything else, is that if you do not have any options to live a safe and normal life, you are going to lie, cheat, and steal every opportunity you get. And that's just what survival mode is.
And oftentimes the trafficking will, prevent them, if they can't get a job, a legitimate job, they may engage in criminal activity to survive, or their trafficker may have forced them to take drugs, or they may have become addicted to drugs or alcohol as a coping mechanism to numb themselves from their trauma. And these are all the things that we have to explain to a court and educate them. And oftentimes we'll, in the petition part where, this is our legal pleading, will include academic research on the connection between drugs and trafficking, or other criminal activity and trafficking, to help understand, why somebody would be engaging in criminal activity after the fact. But, if it happened after, 9 times out of 10, there is a causal connection, and we just have to be able to tell that story, like Nick said.
And other crimes that may not seem obvious too, like check forgery or other financial types of crimes, right? Sometimes the traffickers realize that this is a person who has a relatively clean credit report and clean social security number, and will, you know, make them open up accounts and run credit up in their name. And that's something we've seen before as well. So the nexus really just depends on the extent to which the victim is able to tell their story, tell what happened to them. There's a question, will the training be recorded? Can we get a copy of the recording? Yes, this training is being recorded. We are going to make slides available afterwards. Jamie, are we making the recording available as well?
I believe so, assuming that we don't have any technical difficulties.
Yes.
Then yes.
All right. Is there anything law students can do right now remotely to support this work? We actually have gotten outreach from a number of law students. Love the question. Thank you. Law students, please feel free to email me, Nick, N-I-C-K, @freetothrive.org. If you want to be involved in this work. I run our legal internship program, and I would be happy to speak to you about your interest in this type of work. Alicia asks, are there more survivors of labor trafficking or sex trafficking that seek vacatures through Free to Thrive? Great question. The vast majority are sex trafficking survivors. Labor trafficking has a very different and unique dynamic. Very oftentimes labor trafficking is more involving foreign nationals because of their either undocumented status or foreign status. They tend to not seek out resources or law enforcement to help them. They're much harder to identify. Typically, our clients are identified to us through things such as contact with the law enforcement system. And the way the laws work in this country is if you're not a citizen, a contact with the law enforcement system starts a process to remove you. And so there's a very narrow window to identify and then help victims of labor trafficking as well. It's definitely something we're interested in doing more of.
Absolutely. And one thing that we didn't get a chance to touch on, so I'm glad for this question, is that at Free to Thrive, we believe that forced trafficking of drugs or forced sales of drugs can be labor trafficking if you meet the elements of labor trafficking. And with that, we actually have successfully vacated a record of a survivor in San Diego who was forced to sell drugs by her spouse, who was also her trafficker. And we were able to meet that threshold in that case of showing that she wasn't financially benefiting in any way from this. She was doing it because she had an abusive spouse who would physically abuse her if she didn't do what he wanted her to do. And we were successful in vacating that record.
An anonymous attendee asks if we could share the academic resources. You have a case where a person was given drugs, committed crimes. I'm struggling to tie this into the definition and say this is exploitation. Any thoughts? My first thought would be that the way you would prove that would be through expert testimony first and foremost. The study that we reference most often in our work is the Gates-Carpenter study. It's a collaborative study between Jamie Gates and Amy Carpenter at University of San Diego and Point Loma Nazarene University, that will further explain a lot of the connection between, I think, drugs and committed crimes, but also that's an expert, and I think you'll probably need an expert if that case goes to trial. And
we will, in the materials that we provide you, there is a sample petition, and in there, that petition is from a case that was drugs and theft, and so you will see some of the citations there. There probably have been more studies since we did that particular petition, but yeah, in the pleadings part, there's a ton of academic research out there on this issue, so it shouldn't be too hard to find, but if you're having trouble finding anything, you can always reach out to us.
Okay. Brooke Burris asks, with any partnerships with case management nonprofits, do you have written agreements with them or confidentiality agreements, information sharing agreements, or is the release of information sufficient? Yes, we have all of those with various partnership organizations. The extent to which you have an agreement with them, like any contract, is pretty custom tailored to the situation. Alicia Buckner asks a great question. Do you have men or boys that are trafficked? Is this a thing? Yes, this is absolutely a thing. It is something that is definitely less known than female sexual exploitation. We do have transgendered clients. you know, we know it happens to men and boys. We also know that there are incredible societal pressures on men to you know, keep quiet about bad things that happen to them, to, you know, just sort of suck up your pain, if you will. We also know that the dynamics involving men and boys in trafficking are slightly different than women. But yes, it is absolutely a thing. Linda asks, does your organization accept monetary donations? Yes, we do. Thank you, Linda, for asking that question. Yes, you can donate through our website, or you know, you can give us a call as well. We'd love to speak with anyone who is interested in donating to our organization and supporting our cause.
Thanks for that question.
Yes, thank you. And last question I've got is from Allison. It says, how quickly can new volunteers and attorneys take cases? Is the COVID-19 crisis going to prevent new volunteers for now? No, the COVID-19 crisis is not going to prevent new volunteers for now. How quickly a volunteer attorney can take a case is the extent to which they are motivated to take a case. We have a number of clients that are waiting for vacature petitions right now. There is a process that we go through to screen and further train you just a little bit more to make sure that you feel like you're well equipped to handle these types of cases. But yes, we can absolutely marshal volunteers quickly, and we're eager to do so. So thank you for asking that question. And I've got, sorry, go ahead.
Oh no, it's okay. I will say that our non-attorney volunteers, the main volunteer opportunity is community outreach. So that is something that during this time is limited. For attorneys, we are all still working, we're all still helping our clients, and we definitely need your help. But if you're a non-attorney, but you have some specialized skill set that you think that you can offer to Free to Thrive, please do reach out. No matter what, sign up to be on our listserv, and we'll get back to you when we have more opportunities. But if there's something that you think that you can help us out with specifically during this time period, we'd love to have that conversation.
Okay, and I do have one last question from Aaron. Is California returning fees and fines to survivors once they vacate their conviction? They are not.
No, they do get vacated. So as we said, the restitution doesn't go away currently. We really want to change the law around that, but that's a pretty heavy lift at this point. But fees and fines, they won't be enforced. So people ask, should we have them pay them back? And if you believe your client is eligible for vacature, the answer is no. Like other than restitution, they still have to pay that. But if they have owed fees and fines, do not, I've heard some people advising you have to pay those before you can seek vacature, and that's not true. Please don't tell your clients that. But unfortunately, there's no way of getting them back once they've been paid.
Well, that's it for our Q&A session. Thank you for all the wonderful questions.
Yes, thank you so much all for joining us. We had over 100 participants, and I'm just blown away by this turnout, so thank you. Thank you so much to Philippa, both for joining us today and also for being such a dedicated pro bono attorney and support system for our clients. And thank you, Nick, for your amazing help with the Q&A, and everybody who helped out behind the scenes. You know who you are. Really appreciate it. And I hope you guys will join us for future training. Take care.
Thanks, Jim.